Hi, this is Lynn Walker at Minor & Landis bringing you a quick update. As we are approaching February 2021, it can only mean one thing: the beginning of H-1B cap season. The chaotic period from February to April, when hundreds of thousands of H-1B registrations or cap petitions are prepared and filed with USCIS with the hope of obtaining one of 85,000 H-1B visas that are made available each fiscal period. During last year's cap season, USCIS received approximately 275,000 H-1B registrations for only 85,000 H-1B visas that were made available, which means the odds of getting selected were no more than 30%. Every H-1B cap season creates significant drama and anxiety for employers, foreign nationals, and immigration professionals, even experienced ones like myself. So I'd like to take this opportunity to offer some positive feedback or guidance on what we can do to mitigate these anxieties so that we can work together as a team so we can timely file either the H-1B registrations and/or petitions. So what can employers do to remedy some of these anxieties? By February, the employer should know whether the company will be sponsoring a foreign national for an H-1B visa for this fiscal period. This is not a decision that should be left until March, when it is too late to collect the required information and documentation from all the parties. Second, the employer should know the title, job duties, and salary being offered to the sponsored foreign national, and whether the foreign national possesses a bachelor's degree in a specialized field of study related to the position, or a U.S. master's degree in a specialized field of study related to the position. Third, the employer should know the location, more specifically, the exact address where the foreign national will work and perform his or her services. The employer should take into consideration the following: will there be a primary place of employment or a secondary place of employment that encompasses work-from-home scenarios due to COVID-19 pandemic or other such emergencies? Fourth, it is highly recommended in cases where USCIS implements its H-1B electronic registration program that employers proactively file the required labor condition application in advance of the registration in order to ensure timely processing and approval of the LCA. As important as this is for employers, what can foreign nationals do to help ease the anxiety around H-1B cap season? First, the foreign national should advise their employer and immigration professional if they have any dependents in the United States and what each dependent's immigration status is. If you have a dependent in the U.S., you will need to provide a copy of their passport pages, marriage certificates, and/or birth certificates. Second, you need to collect and provide your employer and immigration counsel with all of the following documentation, ensuring that the copies you provide are legible. These documents include, but are not limited to, the biographic and U.S. visa pages of your current passport. If you've ever entered the U.S. using another, older passport, provide the biographic and U.S. visa pages of that passport as well. You should also provide your Form I-94 arrival departure record. If you are currently in the U.S. in F1 status, you should provide a complete copy of all I-20s. That means the front and back pages. You also need to provide a complete copy of your college degrees. That includes your diplomas and transcripts for each educational level, from baccalaureate degree through master's, and if you have one, a doctoral degree. You should also provide your resume or CV, clearly listing the name of your employers, the dates of employment. By dates of employment, we mean month and year, your title, your duties, and the immigration status or work authorization you held for each position. If you have ever been present in the United States in another non-immigrant status, such as J1, J2, L1, or L2, you will need to provide documentation confirming your status and that you have maintained your non-immigrant status throughout your stay in the United States. The failure to timely collect and provide all of this documentation will result in the delay in the processing of your H-1B registration and H-1B petition. It is truly imperative that employers and their foreign national employees work together to collect and provide all of this documentation to their immigration counsel as soon as possible. I would like to thank our fantastic immigration paralegal, Ms. Rosa Munoz, for providing me with her keen insights and working with me on creating this post. Rosa has more than 20 years of immigration experience and has been working with many clients during the H-1B cap season and understands the anxieties and issues that can create delays in the processing of H-1B petitions. Rosa possesses significant experience and in-depth knowledge and is able to navigate through the H-1B process and provide clients with guidance during these particularly hectic times. If you have any questions about the H-1B cap or require legal assistance, please feel free to contact Minor and Landis's Immigration Law Group at 973-624-2800. Minor and Landis's Immigration Group provides services of only the highest quality at a reasonable cost. Its attorneys and paralegals are not only extremely experienced and highly motivated, but also highly responsive to clients' needs. Attorneys are directly involved in all cases with phone calls and emails receiving prompt responses. Thank you very much.